The purpose of this project is really just to address the need that we have seen in the community for pro bono attorneys, or actually any attorney representing tenants in eviction cases. If you are not familiar, Princeton did a survey through the Eviction Lab, and it showed in 2016 that North Charleston was #1 in the country for the highest eviction rate. And so we felt that was very, very, very disturbing, and we wanted to do our best to address that. And so, you know, we kind of looked at it, and those of us who are here presenting, we all have experience working in this area with evictions and low-income tenants and the indigent population, and we see that when there is not an attorney on the side representing the tenants, evictions are way more likely than they would be if there was an attorney representing, because as any other case in court, if you have attorneys on both sides, you can make sure that the law is followed and justice is actually done the way it's to be done. However, with evictions, most tenants don't have attorneys, so they don't know their rights, they don't know the law, they don't know what can happen and what can result, and so unfortunately, the worst usually happens for them. And so we're doing our best to provide access to justice for these low-income tenants. So that's what we're here today, to kind of let you know and see what an eviction case kind of looks like. It's nothing to be scared of, and we're seeking your assistance in representing these tenants as much time as you can give, so that we can prevent the evictions and keep people in their homes. When people are displaced and they lose their homes, especially families, you know, the kids have to change schools, you know, they become homeless. Jeff and I end up seeing them at the homeless shelter, and that's no life for anybody. So we want to make sure that we're doing our best to help people keep their homes and help landlords keep keep tenants in their homes, because it's expensive for the landlords as well to continue to go through the process of evicting people and finding new tenants. So we want to create a solution that works for everybody on both sides. And really, it's just an access to justice issue that we're hoping to work on solving in our community and state. I think do you want us to just go ahead? What do you?
I guess you better go to take some text.
Yeah, so Nicole, you were gonna kick us off. So Nicole with Charleston Pro Bono Legal Services.
Hi everybody. Do we have our computer and projector set up?
Nope.
I do.
That's why I've got a foot.
Yep. Has the housing court manual gone out?
No, what do you mean?
No? Okay. The documents that I'm going to show you is basically a real short flow chart on how to defend an eviction. We have a manual that is prepared for everyone. It's being loaded to the Charleston County Bar website.
No,
South Carolina
Bar
Bar website.
website. It should be on there by now. I talked to Betsy yesterday and finalized things.
One of the things that is in there at the very introduction of that manual is a outline on how to defend these cases. So in addition to a wonderful PowerPoint presentation that Adam Prothero with Appleseed presented to us and allowed for sharing, we also have a concise, it's like 4 pages long flow chart for the 3 common issues you see, or the 3 issues that can be checked on an application for ejectment, which is non-payment of rent, end of lease term, or violation of lease, and how you as an attorney would triage those cases, evaluate the issues, and what objections you may want to raise, or what options you may need to look for your tenant to sort of negotiate that later vacancy date and compliance payment, if that is allowable. So I really do need to show you the visual aids for the purposes of that.
We will follow up with an email today, because we're going to give a link that Betsy gives us for the documents.
Right.
We're going to send a doodle for sign up for housing court dates. So anyone who signed in today will get an email follow up for easy access to the links.
Might be our access right there. That's the screen, but somebody's coming through judge and jury working on findings. Their IT person is off today, so that's why we're having some issues right now.
Is the manual printed?
Well, this is.
It will be printed and
I have
held
a copy.
here at
If
the
you want a hard
courthouse.
copy, I can.
Yep, it will be printed here, so
This younger lawyer wants to argue.
And there will be one.
it's pretty big. So you might, if you're gonna make copies.
There will be at the court. There will be a banker's box with supplies and with the manual inside that.
Oh, great.
I can tell you what's contained in the manual so that you can at least know what that is now. The portion that I was gonna go over with you was going to just be that triage document. That's gonna be the one that we would ask that attorneys carry with them because it is short and it'll tell you the answers for about 85% of the cases you'll see. Those other 15% are most likely to be HUD tenancies, and there's also instructions in there how to ask for a continuance if that is something outside of the scope of the pilot program. What is contained in the manual, and the manual will be located every single one of the sites with a table of contents, with the documents that you might need, and a few extra forms that you might find helpful. We have the triage document that's going to show you how to walk through your eviction cases and be familiar with it. How to defend an eviction with Adam's wonderful PowerPoint. The relevant sections of law, which are the South Carolina Residential Landlord Tenant Act, the section on rents, landlord and tenant generally, and the ejectment of tenants code sections. We've also included the county code of ordinances, and we're trying to get the relevant sections of the city of North Charleston code of ordinances. You'll need to know from the GIS which set of ordinances you're dealing with, whether it's unincorporated county or whether it's incorporated in a municipality, so that you're using the correct ordinances. But we'll have those available to you, and you will have it on site if you need to draw an extra ordinance that maybe you didn't bring with you. You can bring it up and reference your source of law. We've also included a section with magistrate court information, the magistrate directory, the court rules, section N on landlord-tenant law from the bench book. Instructions for eviction hearings is a form that all of the tenants are going to be receiving, along with the pilot program form and instructions. You'll also see a sample rule to vacate or show cause. Your tenant should have one with them when they come to court, but to give you an opportunity to be familiar with the forms used here, we included that as well as the writ of ejectment form and the form that magistrate court uses for a subpoena of a witness. Some additional forms we've included that are more tenant forms for the benefit of the tenant going forward are those forms that are from the Judge George W. Jefferson South Carolina Practitioner's Manual on Landlord and Tenant Law. Can't buy it right now because it's in reprinting. They do have 2 copies at the law school that have those forms on CD-ROM. If you have a computer with a CD-ROM, you can get those form banks, but the relevant ones are included in the Housing Court Manual. That's the 14-day demand for repairs, the sample responsive pleadings that you may want to use if you got to do a notice of retaliation defense, or if you're going to be receiving the case in advance of the day in housing court and want to give some notices of representation. We also have the tenant forms on notices of substantial casualties such as a fire or flood, hurricane damage, notices for failure to provide essential services, both the procure and deduct remedy as well as the termination remedy notices, and then the demand for the return of security deposit under section 410. The last section is just supplemental documents. This is what you might find most relevant for you. There is a brief included in the Housing Court Manual that is a U.S. Supreme Court brief with a lot of law and well-sourced information that if you are a private attorney and you've accepted a case pro bono, that does not mean that if a statute authorizes recovery of attorney's fees, you're not going to get those attorney's fees and don't have a claim to them. The opposite is true. If the statutory law says, and you may recover attorney's fees, even though you've agreed to take that case on pro bono, you have a right to make a motion for those attorney's fees because it's part of the statutory damages and relief, and you can offer that brief. That will be in there. We also have a case in there on attorney fee awards and landlord-tenant cases. That's the Previtt versus Ashbury Arms case. And then we included a copy of the State Fair Housing Act. Is that?
We're going to see where it hits, so I might need to edit this up a little bit.
Okay.
It should.
So that is what's contained in the manual. Yes, sir.
Will the cases be here in the courtroom?
So we're going
We won't
to
be
do
down
Wednesdays.
anywhere else?
For now, the first section or first iteration of the actual housing court is going to start on October 2nd, and it's always going to be a Wednesday except for we have a few holiday weeks where there's court closures, and those weeks it's being moved to Thursday.
But it'll be this magistrate.
This magistrate court for starters, eventually West Ashley and North Area 3, that's Judge Steinberg's court and Judge Semmy's court, will be the part of the scope of the program.
And will we only be dealing with evictions? Or
Yes.
particular types of evictions?
Right now, it is just eviction cases. We have not included section
Yeah, just eviction.
Oh, we have not included section 8 tenancies for reasons of, consideration to our volunteer attorneys. We've asked that if you do get on a case by mistake that is a section 8 tenancy, such as a project-based or a housing choice voucher situation, that you go ahead and move for those continuances because they have additional remedies for tenants, an opportunity to inspect the file.
But we won't be dealing with notices of lack of essential services or, those come up in defenses.
Right.
Those can be raised as defenses under section 630 of the Act. If it's a retaliatory eviction, there is a requirement under section 910 that you have to give 10 days notice to the landlord of your intent to bring that defense at trial. So if the hearing is set for October 2nd and you're giving notice of intent to bring retaliation defense on October 1st, that's not going to fly. That needs to be a continuance, and it really needs to go into the hands of somebody that's more familiar with that practice. Continuances are supposed to be granted under this program for, good and sufficient reason. That would be a good and sufficient reason. Was there another question?
What about the paperwork requirements?
Notices of representation and such?
Yeah.
So we talked about that. I had originally planned on including a written notice of representation in the file, but the understanding was that if you're here as the attorney for housing court, that notice that's your day is already sent out to all of the parties. So double notice is basically what that would be. If they're
Yeah,
We're
the
not
judges aren't
requiring it because it's going to be noticed anyways on the calendar. Now, if there are cases where 211 has been contacted and they've referred the tenants in those housing court cases to 180 Place, Charleston Pro Bono, Legal Access, South Carolina Legal Services, or a private attorney, we will be sending those notices of representation if they're given to us in advance. But for the attorney who's representing housing court or present for housing court, because they're already on the calendar, they're just going to be the fill-in for the other locations, and that is out and noticed. So if you get one.
There's no, doesn't sound like there's much exchange of correspondence and pleadings and all that. That's what I'm talking about.
So we're still looking at, everyone's going to be doing the application or rule to vacate forms, and we're still looking at any cases that is triaged in advance of the court date by that attorney, sending notice to counsel under regular magistrate court, give the heads up, voluntary share of information, no discovery. If it is something that does require a written notice, like those retaliation defenses or intent to raise the 630 defenses and show evidence as to those, you have to follow the rules the same in housing court. The only thing that we are relaxing on is those notices of representation, simply because it is disclosed publicly that there is an attorney on those cases.
As far as pleadings and stuff, no, you will
And
not have, go ahead.
You won't have any triage in these cases beforehand.
No.
For the people, for your intents and purposes, you're going to be showing up on housing court date. The only thing you'll have done beforehand is run a conflicts check from the docket, but you won't have any other information about the case until you show up there. And all of that will just happen at the hearing will be when you present your defense if you have one. If it's something more complicated, you can ask for a continuance.
No discovery, no.
No.
Discovery,
We
no
don't really
exchange
have
with the
discovery in
landlord.
magistrate
Okay.
court.
It's much more succinct. I mean, these are
All
pretty simple cases typically, so.
You'll be
The vast
speaking-
majority are non-payment.
Right.
Yeah,
Right.
so you'll just be meeting with the client and asking,
Did you pay the rent?
did you pay the rent, why not?
Right.
And picking out,
Direct
why they
example.
didn't, those kind of things, see if there's an offense there. Yeah.
Could you all address the role of the law students, what they're going to be doing as well?
It's coming up,
Yeah.
absolutely,
Okay.
we are. We're actually trying to get that set up.
Okay.
That's what Sarah and I are gonna talk about.
Okay,
Yeah.
and about the realistic expectations here, because it sounds like there may be, or will there be instances in which our tenant gets evicted?
There will be. I mean,
Right.
there's always going to be
Showing up.
cases where there's an
Sure,
offense.
absolutely.
So it's not, we're coming in and.
You're not gonna
saying
come
first
in and save the day every time,
Yeah.
unfortunately,
Okay.
but yes, you're right. There could be, it could be, but as we'll explain, even if your tenant does not have a case, they just didn't pay rent they should have, and the landlord's just like, I'm sorry, you gotta go. As a lawyer, you can still, ask for a move-out date talk to the landlord, see if you can negotiate a fair move-out date, and negotiate a writ of ejectment actually not be issued by the court, so there's not actual eviction on the tenant's record. You
And
can ask.
options for where they might go afterwards and everything.
We have resources that you can direct your tenants to for things like rental assistance payments, for coordination of housing subsequent. If they're a veteran, there are a lot of programs and there's more available to them, but also things like the navigation center is a great place to go and look for resources if there's an impairment to the tenant being able to find subsequent tenancy. And then also, we do include information about public housing if there is any open wait lists or any special considerations, Office of Special Needs Housing.
But as far as your role in the court,
Yeah, that's not
it's
really-
just to advocate for your client and just say, look, we understand, and try to mediate with the landlord ahead of time. Just say, look, we understand rent wasn't paid. My client will be out by this date, within a fair amount of time. Is that amenable to you? And then if it is, then a lot of times you can ask and just say, we've worked it out, Your Honor. Because the judge is going to ask, did you speak to the other side? Did y'all come to an agreement? And you can say, we've worked out an agreement. And then we just request that the eviction not be on the record, but we agree to be out this time. A lot of times the judge will say, that's fine, be out by this date. If you're not out by this date, then the landlord can come back and do a writ.
Not to do any war stories, but I just had one this week where I had a hearing last week. He owed 2 months back rent and didn't have it. The judge gave me a week to get him the money together. He got all but $296 of it together. Judge said, I'm sorry, I'm going to have to evict you. But the landlord who we were working with said, if you can come up at 296 before the sheriff comes to move him out, then I won't evict him. And he came up with $296, but he wouldn't evict him. So the judges will work with you and do what they can. None of the judges and most of the landlords aren't interested in evicting people if we can come up with a plan.
Yeah. And there are quite a few landlord attorney firms that I've dealt with in the past that are, they're very reasonable counsel, they act very professionally, they want to keep a tenant rather than have a unit and have to vacate, find new occupancy, that they are willing to negotiate within, reasonable means to try and secure a tenant or keep a tenant and secure compliance from that tenant. What we're really trying to address here is the number of evictions granted and also the number of filings that are either improper on notice grounds or the legal grounds for the eviction sought. We're also trying to discourage people from feeling like they don't have the ability to come to court and tell if they have a legitimate defense. So our plan is to try and get those wrongful eviction numbers down.
And just so, outside of your role, before, when a tenant in this program is being sent the rule to vacate, saying, hey, your landlord intends to evict you, the court is sending with the tenant, with the eviction notices right now, a sheet, an information sheet that says, first and foremost, you have a right to a hearing. If you disagree with this or you want to contest this, you must request that hearing within 10 days. Then it says you also may be eligible for an attorney. Call 211 to see if you're eligible. So we're hoping that a lot of the tenants who are getting these eviction notices are going to call ahead of time, call 211 and maybe get assigned to one of us if they're income eligible. And then if they don't, it's also going to say, I believe it's going to say, there may be an attorney on site and you may qualify for it. So we'll tell you the process in just a moment. Oh, look, are we good?
Yeah.
Okay, so we're going to tell you the process of what the day of is going to look like. And yeah, there will be an interview intake to see if people are eligible, because not everyone's going to be eligible.
All right, I'm gonna grab a flash drive real quick.
Let's just go through this real quick. Okay, the second part.
Flash drive, well, there should be one. Yep. All right, so this is the document that is going to be included in the housing court manual as well as up on the bar website, and also this is what we would ask that you would keep with you just as a reference guide. There are a few more edits going onto it to be included that we were making last night, but it'll all be up by this afternoon. The way we've done it is we've assessed that there are only the 3 grounds that you'll see on an application. All 3 may be checked on your application. You may have to triage for each one of them, but we are going to demonstrate how this would work in practicality through the mock trial. So we have failure to pay rent when due or demanded, end of lease term, or tenancy is ended, violation of the lease. And the plaintiff must state what that violation is with sufficient detail to meet the pleadings requirements. You can't just say it's damage. We don't know what that damage is or what that means. Pleadings, friends, you need to have enough notice to be able to prepare a legitimate defense. So some of the preliminary issues that you'll see, shockingly enough, I've had standing come up several times in my eviction cases. Is the plaintiff the owner of the property? If they're not the owner, do they have a management agreement? Are they authorized to exert control over this property? If it is your grandma's property and you are not a property manager and you have no contract for representation, your name's not on the deed, and you have no connection to that asset, you are not able to file those cases on grandma's behalf. Just because she names you as the person on her medical directive, that doesn't mean you're in charge of her real property. So you do just want to make sure that the person who's filed the action and has offered themselves as the landlord to the court really is somebody that can bring that action. We've had really several cases like this, and a few of them were even professional property managers, but they had contracted with somebody that did not own the asset to manage it, and that contract fails because there's no connection to the property. So do find out if they are someone who can self-represent, if they don't have counsel, and that they do have a connection to that property, otherwise move for dismissal for lack of standing. If we're dealing with a property manager and the property manager is not, or is, contracting with the owner, we want to make sure that that is truly a licensed property manager or somebody that can act in that capacity. Certain types of litigation allow for a non-attorney representative, somebody who works for the management company, somebody who has a form on file with the magistrate court. Otherwise, we're looking at a situation of unauthorized practice of law. And remember, a PR cannot represent an estate owning the premises in this kind of action. They have to have counsel or somebody else that can act in that capacity. Also, is tenant in possession of the property or have they vacated the premises? This is a possessory action where the case for ejectment is over who's going to actually be able to enter the premises and who's in control of it. So if the tenant has surrendered premises, if this is an application for ejectment after tenant has already vacated the premises, returned the keys, and given notice to landlord for demand of return of security deposit, then this was never supposed to have been filed. They knew that the tenant had vacated. They'd actually taken steps to surrender the premises, and really it should be dismissed on a frivolous filing ground because they had actual notice that the tenancy had been returned. And we have gotten Rule 11 sanctions in cases like this, and we've also gotten retaliation damages from some of our courts where we were able to show that this was just really a malicious filing for the purposes of putting an eviction on a tenant's record, that they were unhappy with that tenant. That's not going to be your usual case. The first ground on the application would be failure to pay rent, and this is probably going to be the majority of the cases you will see. So this is a little bit more thorough than the other sections. Compliance, can the tenant prove that they paid the full amount of rent due on the lease when the payment was due? Rent under the act is the actual rent. Any included utilities that are specified as part of the rent by the lease, so you'll have to look at the lease and see if the rent includes utilities and is not billed separately, if it's going to fall within rent, and then also late fees. There are other fees that are not really part of the rent. You're going to have to look at the lease carefully and then also look at that definition of rent. But if your tenant comes at you, and I've had a tenant come out with me with 23 years of rental payment receipts, and that was a very complete defense to bring in on an action for non-payment of rent. again, is the tenant within the initial term of lease? If the tenant is within the initial term of lease and tenant can prove compliance with the payment of rental amount, then the landlord is either adding fees or disputing the amount of rent. So you will want to take a real close look at what the lease says about those fees, and also look at the appropriateness of the fees. If we're looking at a late fee that is 60% of the rent amount, that could be challenged on unconscionability grounds. In this market, we've seen a lot of, for lack of a better term, limiters for the amount of late fee down to 15 or 20% of the rental amount. So just, make sure that you're not charging or being assessed a late fee that is extraordinary and prohibitive, such that it would rise to the level of unconscionability.
And Nicole, just to interject, this court, every court may be different, but this court doesn't enforce late fees above 15%.
That's good to know, guys, because she's gonna be the
Okay.
judge here.
Well,
So,
I will tell you that the
15%
entirety of
of
the
the
document, the entirety of the document is here for you with sample objections and the code sections relevant to them. So do make yourself familiar with it. This is not a long document. It's only about 3 or 4 pages long. You will have a copy of it, and it walks you through the entirety of it. In the interest of time, we would ask that, give us a little deference here and review that yourself. If you have any questions, my email is npaluzzi, P-A-L-U-Z-Z-I, @charlestonprobono.org. Feel free to email me. Everybody else does. And I'm happy to address these, but I want to make sure that Sarah gets a chance to show you the PowerPoint. So this is there. I don't know if I've been standing in front of it this whole time. You'll have the opportunity to review it and look at end of lease term, and then violations of lease terms are included as well. So we've got the basic flow: if this, go there; if that, and you've got nothing else left, try and negotiate, because we're attorneys and that's what we do.
all right, this is a great tool for you guys. They did a great job putting it together. So it kind of just presents, what could happen in the case and the defenses. So definitely make sure you're familiar with it. As we mentioned before, these cases go pretty quick. They're not too involved, not a whole lot. So please don't be scared because you don't really know what's going to happen going in. If you review that and have that on hand, you'll be able to pretty much assess any situation.
I can go ahead and email that to everybody.
Yeah, that'd be
separate from the
great.
manual, so that you-
Yeah, so you can have that separately. We'll email that to you after this. What we're going to do now is Sarah and I are going to kind of go over probably what you're wondering: what is your role and what is the day going to look like, so that you feel a little ready and familiar. All right, so first step. How do we do this?
Yeah, sorry, on the screen.
Sorry, guys.
This is a Zoom.
All
The
right.
court apologizes for its inability to control its own equipment. Lawyers are not known for their technology skills, and I'm a lawyer.
Just raise the projector screen. It'll show the wall.
Yeah.
You've seen the basic. You got it. I mean, we'll also email this to you afterwards if you'd like. Just let us
Raise the
know.
screen, you just use the wall.
Oh, that's
Okay, what's the name?
We're gonna. How do we put the screen up? I think this one right here.
How many lawyers? So long to get that screen down.
This could be
Yeah.
an indication that we need more lawyers to appear here who might have technology,
Yeah.
used to using it.
Okay, guys. So first and foremost, so assuming you've checked, you've got the manual, you know where the manual is, South Carolina Bar Pro Bono site, also hard copy here at the court, and we'll be emailing you as well links to where the pro bono, where the manual is, and then the wonderful instruction sheet that Nicole just went over. So you've got all that stuff. So what happens? What do you do now? So if interested, what we're going to do is after this training, we've got all your emails. We're going to send out a doodle poll of a list for you to put your availability. So every Wednesday morning is when this court's going to be held here. And the time frame of the dockets can be about 9 to 12. Each hearing will be set at a separate time between those 3 hours, 9 to 12. You put down your availability on the Wednesdays that we'll send out. The doodle poll is gonna basically have, when starting at October 2nd forward, every date that we're gonna have court, you will let us know when you're available, and then our wonderful extern and Jeff will work on scheduling you guys to be here on the date that you volunteer. So, before you arrive, confirm your availability with Jeff by emailing him or doing the doodle poll that we let you know. We'll let you know if, hey, we need you on this date, can you be here? Great, we'll schedule you. In addition to scheduling you, we're also scheduling a law student for most dates, assuming their availability, to be here as well to assist you. So you'll contact Jeff, write down his email if you're interested in volunteering. You're also gonna get a doodle poll, whether or not, you tell Jeff or not, because you're on our email list now. You don't have to volunteer, but if you can, we want you to go ahead and fill out that poll. Ahead of time, you're going to check the docket. Now, Judge, how are they going to do that?
So what I think what we'll do is have our clerks here at the court create probably a Word document or something simple like that that can be emailed. So if you'll check with the court, provide your email address. So if you're going to be here on the Wednesday, you could probably easily check it by the Friday before. We'll have it ready by the Friday before, and that should be a final docket. It may even be earlier than that, but definitely by the Friday. So you can call, give your email address, let the clerk email you the docket. That way you can do your conflicts checks at the end or the beginning of the week.
So go ahead.
And we'll send out a reminder email, so we are gonna schedule these out through the end of the year. But we'll send you a reminder email the week before you're scheduled to volunteer that reminds you to reach out to the clerk to get the docket, reminds you that you're volunteering so that if something has come up and you need to be reassigned to another day, you can just let us know, and we'll, from the doodle have a list of everybody's availability, so we'll find somebody else to replace you for that day.
Yeah. So check the docket, review it, make sure that there's no, check with your firm, make sure there's no conflicts, do a conflicts check just so that when you come in, you have a list of the tenants that should be here for their hearing. So you know who you will be interacting with. So you'll know ahead of time if there's conflicts with a particular person or other side or not. So once that's done, you have the manual, you can review all that, print copies of the forms that you need. Again, we'll make sure we have that stuff in the email ahead of time of the forms that you're going to need, and we'll be going over those shortly in just a moment. So when you get here, we're asking tenants if they want to be screened for an attorney. If they have not already, most tenants that are coming are not going to have attorneys because this docket day is only scheduling tenants who are not represented currently. So they will not have attorneys. So we're telling them, you may be eligible for an attorney. If you want to be screened for an attorney that day, you need to arrive about 8:30. 8:30 will be when the law students are going to be arriving. If you can arrive at 8:30, that would be fantastic. That's what we're asking. And then one of us from the legal service agencies will be here on site as well to assist you. That's when screening will start. We have an intake form that you will see ahead of time, and the law students are going to be assisting you in screening for intake these particular tenants to see if they qualify and what their issues are and that kind of thing. So you will sit in on those screenings as well, so you can go ahead and kind of get a feel for the case with the tenant. So once you've done the intake and screening, you can have them sign the limited representation agreement. That will also be provided to you. There will be copies of those forms here in the court as well. If you've forgotten your form or whatever, we'll have all that in the banker's box that you can just get a copy made or a few copies already made for you that you'll be able to use. And then the hearings will start at 9. So before the hearing really is when the intake process starts, where you just start interviewing the clients, getting as much information as quick as possible. It is going to go kind of fast. And then you'll know what time the hearing is. So like say you have a 9 o'clock hearing, you're going to want to talk to that landlord if that landlord shows at a time. Now here, if the landlord or the other side never shows, you're going to ask to dismiss the case. Because if their person who's bringing the case is not here, that's what you want to do. However, if they do show, you want to make sure you try to speak to them beforehand as well before the case. There should be some time in between hearings as well for you to kind of consult with the client on the other side as well. Did you want to add anything on that?
I would just say that, you can tell it's a tight timeline, you're gonna get there at 8:30 and all of a sudden start hearings at 9, but I just wouldn't be too worried about it. We're gonna have the law student there, we're gonna have the legal services attorney there, so really your goal is gonna be to meet with the tenants in the order that their hearings are, so that, as soon as the first intake is done with that first person who has a hearing, you're sitting down with them, you're figuring out if they have a defense, and you're getting up in front of the court. And then there will be, like Mary said, there should be a little bit of time in between, so that if you need to sit down with the tenant for the next hearing right before, we can work with that and try to get you some time with your clients.
But it will move pretty fast, but as you'll understand, as you get more familiar, the cases most of them are not real involved. And so it is, a lot of time, it's just a quick conversation with the other side, with the landlord or property manager. Hey, what's going on? What can we work out? And then you go in front of the judge, you present that, and then the judge will review that and decide to affirm it or not.
So I'm going to go over the fun stuff, the housing court forms that you should be familiar with ahead of time. These are kind of the logistical forms that you'll need to know about. The first is a screening form, the intake form. The second is the limited rep agreement. The third is a South Carolina bar malpractice insurance form, and the fourth is a case closing form. So first, the screening form. This is a fairly comprehensive form. Its main goals are really to determine whether or not the tenant is eligible for our services, collect data for tracking for this pilot program. We need to see if we're being successful. We want to know what the issues are that we're seeing over and over again. So we're going to ask for some of that information in this screening process. And then also to help identify what the merits of the tenant's case are. So that when you, the pro bono attorney, sit down and flip through that intake form, it should be pretty clear. There wasn't notice, or this is a non-payment of rent case. All those issues will be laid out by the questions asked by the law. And that first page is a notice to the applicants. That'll be on the front of the intake form. It basically explains these goals, explains that there's a possibility that they might not be eligible, that their income may be too high, they may not be eligible for our services, that there also, a conflict may come up during the screening process, and if either of those things happen, we may be able to refer them to another lawyer. If there are a lot of cases, say that there are 5 hearings and all the tenants show up at 8:30, we will probably hand these intake forms out to the tenants so they can start filling it out on their own, so they'll be able to read this form. If you're just sitting down for the first time with the tenant and going over this form, just explain what's on this notice to them, and then I would just tear it off, and that's something that they can. So the first section of the form is just initial intake information, pretty self-explanatory. You need to make sure that they don't already have a lawyer, kind of get a sense of their history with housing issues and whether this is their first eviction or not. The second section, the second page is pretty important. This is where we determine their eligibility for our services. So in order to be covered by the South Carolina bar malpractice insurance, all the tenants have to be at or below 200% of the federal poverty guidelines. And to determine that, we look at their household income. So it's not just what the tenant makes, it's what everybody in their household makes, anybody over the age of 18, and also the number of people in that household. And when we say income, it's not just wages, it's also Social Security, if they're getting child support and alimony, any other benefits, pension payments, things like that. So this kind of outlines what you're looking for, and we'll give you a sense of what that household is. And then we'll look at the chart, determine if they're at or below that level, and whether or not they qualify. If they don't qualify, if they make too much to qualify for our services, there's a referral page on the back of the intake form that includes organizations like Charleston Legal Access, where I work, where we take people from 200 to 400% of the federal poverty guidelines. And if that's the case, essentially what you can tell them is that they, may be eligible to get an attorney somewhere else. If they'd like, they can ask the court for a continuance for that time, and it'll be up to the judge whether or not that's granted.
The hope is that they've already done this beforehand, because that instruction sheet that goes out tells them you may be eligible for an attorney. Call 211 if you want an attorney. So hopefully they would have done that. If they have not, and they don't qualify for our services, then it's really up to the judge if she wants to grant a continuance for them then to go get counsel.
And I do want to say that we're already getting calls from the 211 referrals for the first couple of weeks in housing court.
Yep.
How will we know if someone's called in beforehand and done the eligibility versus, like, what would be indicated from?
If they call 211 to try to get screened at that point,
Yes.
you're saying? Well, what'll happen is when they call 211, they'll actually get referred, be given the phone number of Charleston Pro Bono or CLA. And when they call one of us, they'll get an attorney, and then we'll call the court and get a different hearing date. So you
They
won't
won't
be
even
sitting
be
in
there.
Yeah. That's kind of part one of this whole process, is to get people to get lawyers before they get to court. And those aren't going to be the people you're seeing. You're going to see the people who
did
got
not
a hearing but didn't call 211, didn't get a lawyer, and now we're going to have to determine their eligibility day after.
The information sheets that tenants receive with their service papers when they're served with the eviction notice doesn't even say that you can show up and get a free lawyer.
Right.
It says you have to call 211 if you want to be screened for the possibility of pro bono representation. So this is really a fallback for the folks who just don't plan ahead, who haven't gotten the notice, that 211 is the first step they should take, and then call the court as the second step. So it's going to be trial and error, and we're going to just try and see how, but we're trying to keep this docket for folks who are unrepresented that day. So sometimes there may be someone who shows up and on the docket who's already contacted and is in the process of getting one of these pro bono attorneys, agencies, but we're trying to eliminate that. It's just going to be trial and error to see how it works out in the first couple of weeks.
Thank you.
Yes.
As to the income, we're just relying on what they represent to us, not
Yeah.
for
Yeah.
proof of it.
Yeah.
At this point, we're not requiring any sort of proof of income, just take it from
Okay.
So, assuming that they do qualify for representation, the next section is intended to assess the merits of their case. So this will be really helpful for you all as the volunteer attorneys, and really asks pointed questions that should walk through the basic defenses that Nicole just talked about. So, oh, and then the other thing that this section also does is ask more questions about the property manager. If the owner goes by a different name, so there is a chance that when you go through this beginning part, you'll realize that there maybe a conflict does exist that you know about. If you know about the conflict, let us know immediately, and we will have somebody else step in, probably the legal services attorney who's there. Let's say if you just know offhand that you represented the property manager, the owner by a different name. There's no need, obviously, to go back and do a full conflicts check at that point. You won't have time because it's just going to be on the spot. But if you do know, we need to know that. But then otherwise, it goes through the merits of the case. Why did they stop paying rent if it's failure to pay rent case? Whether or not there was proper notice. So it asks all of these questions, and you'll see that. And the purpose of this too is just to make sure, I know that many of you aren't familiar with landlord-tenant cases. This isn't something you do regularly, so make sure you're not missing things, that you're asking the right questions that need to be asked. The last part is just a summary for the intake attorney or the law student to let you know anything that's not on the otherwise asked on the sheet, kind of give you a summary of what their take on the case is, and then to put what we're doing with the case here. So whether or not we are representing them, if we decline representation, why? And that's just for our records to get a sense of why are we not taking cases,
Who are we referring to?
The other thing that Mary just pointed out is that there also may be temporary financial assistance for rent from Trident Urban League, who's partnering with us as well, so that'll be a good resource. If we're representing them, and even if we can't represent them, then that's a good person or a good organization to refer the tenants to. That if it's really just a straight non-payment of rent, but it's just this 1 month that they've gotten behind and it's not kind of a recurring thing, that can be a really good resource to get people out of a bad spot.
We've applied for a grant, or they've applied for a grant for some more funding to provide some income assistance, some rental assistance. document that's like, look, my paycheck was late this month, so I just didn't get my rent in time. I just need assistance with this 1 month, but next month I'll be just fine. Then maybe that's an option, and you call them to see if they have the money, and they might be able to say, yeah, we can cover the rent for this month, and then you can put that on the record with the judge and kind of go from there.
Sarah? Yes. Can you talk a little bit about if a client is there and they start raising other legal issues, like tips for the pro bono attorneys as to kind of how to handle that?
That's a good question. I mean, if you don't feel comfortable handling it, there will be a legal services attorney there that you can pull in, and we're used to dealing with that type of thing. But it'll be just important to let them know that, if they have other legal issues, that you're only their lawyer for this one specific issue on this hearing date, what's before the court right then and there. You can give them referrals that, if they have a entirely unrelated issue, you can give them that referral sheet, and it'll give them the numbers for lawyers that they can call at a later time.
And that triage outline also does identify if you have an extraordinary landlord-tenant issue, such as, an essential services situation, or if you've got like a building inspector's order, what you might want to do as the volunteer attorney in either seeking a continuance or making sure that you have access to those documents, because those do raise good defenses. We'll show you that in mock trial as well.
Because you can request a continuance if something comes up and you find that there are some good defenses, but you just can't assert them and you don't have the evidence to assert them right at that time. You can request a continuance and then work with that client. And the continuance usually will be scheduled, within a week?
Yeah,
Within a week,
it'll be a
so
short
it'll
timeframe.
still be pretty quick, but you can be able to request a continuance to then carry through with those defenses, and like Nicole said, all that information will be in the packet, the forms will be, so you can work on the adequate defense for your client.
And there may be things that come up that are related to this specific landlord, but that shouldn't be part of this case. I think they may show you in the mock trial how you can sever those claims, because some of those things should be going to a small claims court if, let's say, the tenant's asking for money from the landlord for certain damages, but it doesn't really qualify as a defense to the possessory action. If you, as the pro bono attorney, want to represent the tenant in those matters, I'm sure that they would love that, but you are not obligated to take on anything beyond what is right before the court that day. The limited representation agreement. So for tenants who you are going to take on, that are eligible and you're going to take on for representation, we'll have this basic representation form that essentially says that you are here representing them for what is before the court that day. This is something that you will then have them sign, and you'll keep this for your own records. If the representation extends beyond the hearing day, and you would like a more detailed representation agreement, that will be up to you, and you can just use whatever your firm of practice typically uses for a representation agreement or an engagement. Next, the malpractice insurance form. So as I mentioned before, the South Carolina Bar is providing malpractice insurance for all of you volunteer attorneys, provided that the tenant is at or below 200% of the federal poverty guidelines. All that they require is you to fill out this form, the top says malpractice form. It's very basic, just their name, what date the hearing is on, and that's the date that your coverage starts. And once you fill this out, so you'll fill this out, and then at the end of the hearing day, like later that day, I would recommend you just send it into the South Carolina Bar by email, fax, or regular mail.
That's
Fill it
your
out for every hearing.
Yeah.
You just need one form because it has all of the clients listed there. So if you took on 3 cases, you can just fill all in the same form. And then finally, there's a case closing form. So this is really for our purposes to track the disposition of each case. It's important because this is where we are able to track the success of the court. For the courts that ended the hearing day, you can finish it then. It'll go to Jeff. If there's continued representation, just submit it once that continued representation ends. But we just really want to know, was this a settlement? Was it dismissed in court? you know, you can see what we ask there. It's pretty straightforward.
For this one, you'll need one form per case. So where the malpractice
This-
form is
exactly.
one form, you could just list the clients, 1, 2, 3, 4. This one, if you had 4 clients, you would have 4 of these sheets.
Yeah.
And so those are kind of the logistical forms. Just kind of a recap. So at the end of the hearing day, you'll submit the completed screening forms. You'll just give those to the legal services attorney who's on site. You'll want to, if the case was continued, make sure that you have your client's information, reach out to, you know the best way to reach out to them, and get in contact pretty quickly. Keep the limited representation agreement for yourself, and then send that malpractice insurance form to the bar. And you can send in that insurance form, even if you're continuing representation, you can send it in right out, as soon as you know who your clients are. And then once you're finished, whether that's the housing court date, or if it extends longer, you'll turn those case closing forms to Jeff, and you can send those by email, and then if it's your general practice, you can send a conclusion of representational letter on, your own letterhead. That's optional and up to you.
Yeah, if your client wants a copy of the limited representation form that you're keeping the original for yourself, our clerks will make a copy for the client to take away so that they have that same information, what the limited representation entails.
And then I'm sure that you'll love it so much that you will want to sign up again.
All right, so that's kind of just the brief overhaul of the cases and what's going to happen the day of. And now we're going to kind of quickly set up for just your little mock trial thing, just to kind of see some issues that might come up and maybe a way to handle them. While they're coming up, we got coffee, if you want to grab some coffee real quick, but we're kind of going to do this quick so we can get you out of here on time.
At this point, are there any other questions?
So I noticed on the Form 2, I understand English. Are we not handling Spanish-speaking clients?
We are.
Okay.
And the court will know ahead of time if they don't speak English, and the court has an interpreter that can actually be here to help with that.
Yeah, and so you'll figure that out in the screening process, and as soon as we've identified a non-English speaker, we'll get that translator involved.
Yes.
Is that translator usually in person or is it?
If we know ahead of time, like for instance, when they call to request the hearing, there should be some sort of indication that they're not English speaking. So when we're doing that, we should be able to call and get a physical interpreter to actually appear. If for some reason someone has made the call for them and didn't indicate that the tenant actually can't speak English, then we can get on the phone translation service. It does. That's how I'll tell you, that's, for whatever reason, we have very few, I have encountered very few non-English speaking tenants. I don't know why. It seems like that wouldn't be the case, but for whatever reason, I've encountered very few. So I typically use the telephone translation service, which does slow things down greatly. But like I said, if we have any indication on the front end, then we'll have an actual interpreter be here, which should make things go more speedily.
And like Judge Michael mentioned, there generally should be an indication beforehand, because they have to call and request a hearing. So, we should know. That's one of the things that we should know about the case beforehand. But otherwise, we'll do it.
So and on that, I think you call it a dingle sign-up sheet or something?
Doodle.
Doodle.
Yeah.
Will there be like other fields if the attorneys do speak Spanish that are volunteering? So we can put this additional information to make it.
That's a wonderful idea. So it may have that field. I will check with our wonderful expert.
We'll see if that's
And
Yeah,
to clarify on the doodle, if you want to volunteer once, just to try this out, don't just pick like one date and hope that it works. Put all of your availability. Just because you sign up 10 different times doesn't mean we're going to ask you to do this 10 times. This is going to be like an LSAT problem. We're going to see who's available on what days and try to match who's doing what. So if you only want to do it once and try it out, but there's 5 of the days that you're available, please check all 5, because then what 180 Place is going to do is determine, looking at the calendar, oh, Jason's available on this date, no one else was, I'm going to put Jason on that date.
Yeah.
So you're not committing to all the times you check, we just want to make sure we know.
It's just availability.
I just want to confirm, the very first time you have any sense of what the issues are the day you meet the client in court?
Yes.
No discovery or anything like that.
Right.
So the client says, Oh, I paid by check, he canceled, I said, where's the check? Oh, I left it at home. Then you get a continuance?
Yes, hopefully they'll come with it, but
And,
yeah.
I mean, it's one of those things, if the landlord's there and you can talk to the landlord
Right.
and
The
say,
landlord may
"Pay
confirm
it."
that, yeah, well, they did pay it, but, you
Yeah.
know.
But that's not really the issue where they're 3 months behind, so.
Right.
just talk to the landlord, but yes, if it's collecting documents and you need more discovery, need more time, get it.
Mhm.
He just did one last week and got $3,000 in attorney's fees, so. There you go.
Yes.
Everyone's like, who, what?
And it's just one attorney for that Wednesday, right?
Yes.
Okay, now is there a cap on, like, do we know at most we'll have 10 cases, or it just varies?
It varies.
You'll know beforehand because you'll see the docket.
Okay.
But yeah, it can be one case, it can be 10, and it can also be 10 on the docket and half of them show up.
Judge, tell them what you're seeing right now.
Yes, so the maximum in any given week, so right now we just schedule things throughout the week, and we schedule things for 7 days out. So if you're a tenant and you call and request a hearing, I'm gonna schedule it for 7 days out because you have to request a jury trial 5 days before your bench trial date. So we have to give ample time if a jury trial request needs to be made. Now, no tenant really understands that, but that's why we schedule it for the 7 days out. So we'll know that 7 days, and right now, in a full week, the max we have is about 13 cases for the whole week. So if we were to put all those into the Wednesday morning, and I will say that of that 13, at least 2 or 3 are not gonna show. They're gonna have settled and resolved things. Now, if they know that they have an attorney, they may not. I'm not sure how that'll affect it, we'll have to just see, but at least some will fall through. Inevitably, our docket is very full, and then things don't always show up. Sometimes people request a hearing just to get a little more time to get themselves together.
And remember, that's 13 for the week. The goal, the first part of this process is trying to get them to call 211 so they have a lawyer. So it won't be necessarily 13 on the housing court. If you look at the docket the week before, and there are a lot of cases, a lot of hearings scheduled, let us know. We'll keep an eye on it too. But do let us know because we can always assign a second attorney if people are available. So if it seems like it's
But we're really only
gonna
gonna
be
have
okay.
one attorney, so don't bail if you could help it. Like if
No.
something comes up, you have to let us know so we can fill it in.
Completely. I'm saying that if you look at this and say, I'm gonna need help that day, one attorney's not enough, then reach out to us.
Yeah, I don't think, unless this project just takes off and word of mouth for the representation just encourages more people to request hearings,
Right.
and we're encountering volume that we haven't previously seen, I think that would be a slim chance, but it's possible. I think that right now for the first hearing date, October 2nd, we only have like 4 or 5 cases lined up. We're gonna cut that off next Wednesday. So nobody else is gonna be added to that docket as of next Wednesday. So we've only got 3 more business days, 3 more business days or so to add to it. So I don't anticipate that it's even gonna be, we should have half-hour increments at that range, but we're trying to first give half-hour increments, and then if we get really full docket, go back down to 15-minute increments. And the court will certainly be open to that being a kind of progressive docket, and if things go over, they go over. I'm trying to be mindful of your time and your commitment to be here through noon. So that's kind of we're gonna do what we can to not go beyond that to the best of our ability.
Since they're calling you 10 days ahead to get on your docket, do you backtrack and give them the 211 information and try to steer them off that docket?
Our first question is, have you already called, if you're interested in having representation, have you already called 211? So that's what the first question
And
is.
do some of them then decide to call 211?
And a lot of them are actually calling in both ways, so that's what I'm saying, our docket, we're gonna have to play with it, because there might be someone who ends up on our docket who's actually already called one of the, and is already being represented by one of the agencies, but we haven't been able to determine that, to take them off the Wednesday docket.
And what day do you have the represented cases?
There's not a specific day, we'll just fit them into the rest of the week.
So if we're going to come observe the represented cases.
You can call the court. Let me give you, while y'all are all here, let me give you our court's phone number. I'm sure it's printed somewhere, but just in case it's not, for ease. It's the North Area 1 Magistrate Court, and our phone number here is 202-6610. So that's the number you'll use to call to request your dockets ahead of time, or if you want to come up, sit and observe, you can call and ask, tell the clerk, whoever answers, what you are interested in doing, and can they give you an eviction a day when there's an eviction docket. We don't really group them together in the normal. We try to, most of the time, accommodate a time that the tenant can come and the landlord can come within that week, or within, that whatever. So this is a new thing for us to just tell everybody they have to be here on one specific day. And we try to give everybody 30 minutes hearing time, and we try to accommodate schedules as best we can. So this will be a work in progress to see how that goes. But you're welcome to come anytime. Just understand that dockets do fall through.
Yeah.
So,
We're gonna send out a contact information sheet, so if you didn't get that number, you're gonna get a sheet of paper that has pro bono's phone numbers, email Nicole, the court's number, CLA's number, Jeff, definitely gonna need to get in contact with Jeff, so you don't have to go look in a million different places for our contact information, it'll all be in one sheet.
And you can email us too, because, this is all Nicole does, for example. She'll know if a case is gonna fall through or not, or what the hearing's gonna be, and she might be able to say, come tag along to this one. Yes, sir.
As a paralegal, how can I help?
That's a great question. We could certainly help with intake screening process, so if you could volunteer to do that, we would certainly appreciate that. And there's gonna be a separate email sent out to volunteers for the screening process, law students and anybody else who can help. Again, it's gonna be the kind of the same doodle, give us your availability, and then we'll assign you to a day. So we'll get you on the list.
I'm gonna do the mock trial and then do any more questions at the end.
Just want to let you know that we did go with a slightly more savvy tenant in this case to show you what could happen and a few more issues than we normally see in trying to keep it close to the center. So this is a fairly balanced case, and we do want you to know your mileage may vary.
Don't be scared if this is real. No, might not be.
Nicole Paluzzi versus Jamie Roper on civil action number 123.
Good morning.
Good morning.
Your name?
Nicole Paluzzi, Rena.
Matt Ellsworth for
Jamie Roper, tenant.
If y'all are going to face the judge, maybe just speak up very loudly, otherwise maybe turn toward us and the judge will not take offense to.
Right. Yeah, just talk to us and not the judge.
Hey, Ms. Paluzzi, you're bringing this action. Want to start this?
Yes, may it please the court. Your Honor, I am a property manager for Ashley Apartments, where we had a tenancy agreement with Miss Jamie Roper. I brought that lease agreement as well as copied it on our application for ejected with the court. And I've also brought a copy of my residential real estate license showing that I am an active property manager in good standing. I've already provided a copy of the lease agreement and the licensure to opposing counsel. The lease agreement specifies the amount of rent, and we would have that admitted as Landlord's Exhibit 1.
Any objection?
No, Judge.
Your Honor, by the terms of the lease agreement, the rent is to be paid in the amount of $900 monthly at the beginning on the first of the month, and it's late after the 5th. This month, September 1st, the rent was due and the tenant did not pay that rent. And I have brought a copy of her tenant ledger, which I've also provided to Attorney Billingsley. Your Honor, we would ask that the ledger be admitted as Plaintiff's Exhibit 2.
Any objections?
No, Judge.
By our accounting, the tenant is delinquent on her rent, and we have asked for ejectment and return of possession of the tenancy for non-payment of rent. We have also filed a second round violation of lease term. The tenant has a cat, and the lease specifies that there is no permitted pet, and that we have given notice to the tenant of the unauthorized pet, and I would like to offer that notice as well. Attorney Billingsley has received a copy of that notice. The notice is dated August 27th, 2019, and was sent to the tenant at her address by certified mail with the tracking information below. I've presented the lease agreement, and that section 12 says no tenant pets. My property management licensure. A tenant ledger showing that the tenant is delinquent and in arrears. We've also asked for $50 in late fees as specified by the lease, and a copy of the notice to tenant that they had an unauthorized pet. Your Honor, we've also brought with us a copy of a photograph of the pet that we were notified about when our service technician provided services after residence on her request. And we would offer this as evidence of the pet.
Any objection to this?
Well, we're not necessarily going to this time be an objection to the picture, but I think we can maybe cut this part out before we even get there. Looking at the notice that was presented, does not comply properly with 274710. That requires a 14-day notice before the lease can be terminated. That notice was sent, I believe it was received by my client on the 28th. This eviction action was filed, let's see when, it was filed on the 9th, and that is less than 14 days from the time that she gave notice of the letter. You have to give 14 days notice. That 14 days has to run prior to you bringing that action as a landlord for an eviction based on that issue. So we would make a motion to dismiss and strike that claim from the complaint and proceed on with it.
I have the lease in front of me. Is that date correct?
The dates are accurate, as you said, but section 12 of the lease says no pets, and it's been 14 days now as of the date of the hearing since she's had the cat.
I understand that, Mr. Lucy, but Mr. Billingsley is correct at 14 days as notice to things to change, and she didn't have it noticed before you filed for the hearing.
But we still want to proceed on the non-payment of rent.
We'll dismiss the. Go ahead, ma'am.
Your Honor, tenant Roper
Do you want to quick timeout and explain to them what just happened?
Yes.
Go ahead.
All right, Matt, why don't you,
Sure.
since you,
This is one of the things you're going to see come up a lot. So when you get a tenant coming in, and you have people getting screened at 4 or 5 people in that triage, you might be able to just issue spot if they're all filling it out real quick. People are going to fall into rent categories, which we have here, a rent problem, but we also have a problem of a violation of the lease. Any violation of the lease, virtually any violation of the lease, unless it's condoned criminal activity, gets a 14-day right to cure under 274710A. So it's very similar, and you'll get this a lot, where I want to request a repair from the landlord, I give a 14-day letter. If they want to evict me for a lease violation, I need a 14-day letter that carries with it a right to cure that breach or default if it's curable. So she gave the right notice, she just filed too quick on that issue. The 14 days had not expired. It has to expire in order for them to say the lease is now terminated and now in possession, and that's why we made the objection. And in this court, I mean, and that's one thing about, in the Charleston area, we have a lot of good judges. They are going to be very good and sharp on these kinds of issues. You know, that's where it came from 710A. And you'll see that a lot. There's not that many landlords in other counties even had issues with magistrates seeing that even come up. People just don't always raise it, but it can be a pet, it can be somebody having a grill, it can be somebody, you know, having somebody live there that's not supposed to. It could be a range of things that violates the lease, but they have to get a right and a chance to cure that. Oftentimes, landlords will not even provide that notice. They just won't even, they will say, you violated the lease, I'm filing the action. And that's usually a pretty easy way to identify an issue real quick. You come in front of Judge Michael before it even starts a lot of times. We kind of let it go a little bit, but if I know that ahead of time before it starts, I'll say, Judge Michael, I think we can get rid of this one real fast. And then we'll raise that issue and go through it.
Is it 14 days from when it's postmarked from the landlord or when the tenant receives it?
We're going with on on date of, sorry, this thing is really hard. We're going off of the date of delivery. So she signed on the 28th.
710A says receipt of the notice, so
Receipt. So if she'd been out of town for 2 weeks, that would be a valid defense as well, but she didn't receive.
possibly, and you're usually not, I mean, you're usually gonna have some kind of an idea of where that is, and not every, most cases are gonna be, they just didn't even send a notice. That's gonna be, I mean, this one was a little more of nuance because it just had not been long enough, and she had a certified letter. Most landlords might mail it, they might confirm it with an email or hand deliver it or something like that, and you might have the day that way. But most of them that I've seen to come up with, they just not even give it.
Don't worry if you miss one of these timeline questions. It's the court's regular practice to look for these 3 standard issues that will come up. And so if you fail to make the connection of when you're here, when the notice to vacate was filed, the judge is likely to ask those questions. So she's not advocating on anybody's behalf, but if you miss that very important question, she will be asking it.
Yeah,
That question's on the screening form, so.
As a lawyer, that day you would say, give her the cat, right?
Yeah, I mean, you'll find that a lot. You're gonna have that a lot of counseling the person and telling them like, you know, we might get you out of this one, but you need to get rid of that. You know, I don't try to argue with my, you know what I'm saying, I'm not gonna argue whether you got cat or not, whatever cat, I'm just gonna tell you right now, this is what you need to do, moving forward. Because a lot of times that tenant coming in, even the landlord, is gonna be a learning experience for them to realize, oh wait, I've gotta send my tenants something like this, or I can get out of court. And for tenants to go, okay, I can, you know, I need to pay attention to what I'm doing, because it's not just rent that'll kick me out, it's other stuff too.
And under these factors, because the landlord did give an actual notice that was properly delivered, they just didn't wait the full 14 days with regular court computation time, we're gonna start that next day and count our 14 days, they could leave the courtroom and go file on that CAT immediately, because the notice was now 14 days, because we've come to trial, it's been more than 14 days since the notice was delivered, so they could file in violation of lease if they left the courtroom.
So the original mailing
Yeah,
stands.
yeah, it does not get thrown out simply because it was premature filing for the instant facts.
Those just
Yeah.
kick down the road.
Right, it's essentially dismissing that claim without prejudice, because it wasn't time yet to bring it.
We're not striking the lease provision.
All right, back in action, go.
Yes, Your Honor. Regarding the notice that we received from tenant Roper, she gave us a 14-day notice to cure, which I brought with us, and they've also brought. Talking about rent. I'm sorry, what? The tenant gave us a letter that stated that the HVAC was not working, that only hot air was coming out, and that they alleged that there was mold in the apartment. So we received the notice. This is that notice. We have it moved into evidence as Plaintiff's Exhibit 3.
No objection to it.
We arranged for Crenshaw's Heating and Air to come out and do service on that unit and confirm that it was functional again. The service took place on the 27th of September, and then we were billed for those services the August 27th. The HVAC unit was refilled with refrigerant, and it was the technician that notified us about the cat. The technician provided the necessary service. We'd ask that that invoice, that paid invoice, be admitted as Plaintiff's Exhibit 4 to show that we fulfilled our obligations to service the unit and bring it back within habitability guidelines, and that rent should have been paid on the 1st.
The date on this is September 27th.
My trial error. It should be August 27th.
Okay.
Well, I mean, normally I probably would object about having the HVAC out there, but I kind of like what he says in it, so I think we'll agree with that.
I'd argue that that's a business record regularly kept, that's our record.
You have one more issue?
Our argument is that tenant has not paid rent, and we've repaired the notice issue before rent was due, such that she would have to pay it, and it is now late.
This is September rent.
September rent, in the amount of $900 for rent, $50 for a late fee.
Bill, you have to say it.
And interesting. Normally, I would normally do some cross-examination real quick. I think we might just move to calling my client in the interest of time to speed things along a little bit. I'm going to call you.
You don't need this right now.
And just as an aside, since we're speeding things along a little bit, there was a notice of inspection that normally I would probably cross-examine her on real fast. That was prior to the repair happening, but we pretend like we've cross-examined her on that, and that's presented in evidence. You have it.
And so, just to be clear what's going on, the tenant, Jamie Roper, gave this notice that the AC wasn't working, and that's why she didn't pay rent. So that's her position, so that's basically her defense to why she hasn't paid rent.
And some of your tenants will have contacted a building or code inspection officer. If it's City of Charleston, that's usually gonna look like this. If it's City of North Charleston, it's gonna be a really thick package. Or the county inspection office, they usually just issue a letter. But these documents, these are from the livability officer, and they carry with them like a white ticket with a penalty. So if you get one of these notice of inspection letters, notice of non-compliance as a landlord, that's usually because the city building inspector, one of the municipality building inspectors has found an issue of substantial non-compliance, and they will identify what that is. Because we're trying not to blind Jamie. This is one where the building inspector has identified that there is an issue with the HVAC unit, that it is extremely hot and the moisture level is so high that there appears to be mold and or mildew or something growing in the drywall unit.
Can I state your name for the record?
Jamie Roper.
All right, and I'll just go over this way, turn a little bit, make sure everybody can hear me. So Ms. Roper, you're the tenant at 1000 Ashley Apartment Drive, apartment 108?
Yes.
And rent came due there in September, and did you pay it?
No,
Can you tell us, why didn't you pay the rent on September?
because the AC is still not working. Neither has the mold been removed.
Okay. The initial notice you gave, that your landlord handed up, was a 14-day notice, and appears it included the HVAC work along with the mold. She also presented an invoice that an HVAC person came out and did some work on August 27th. But did anybody do any work on the mold?
No,
Any mold evaluation?
no, no cleaning, no anything.
You say, how long after the repairman came out did it stop working again there for their condition?
Probably the next 2 days.
Okay, did you give your landlord
I
notice?
called her again
When was that?
2 days after the date that, they came on the 26th, I think I called her on the 28th. It was 2 days later I called her. She didn't respond to my call.
Has another repair person come out there?
No,
Has anybody come out since then for the mold?
no,
Has your landlord made any other efforts to fix these repairs?
no.
Any other contact with your landlord about it?
No, I've been trying to call her and she hasn't received my call. She's not answering.
That's all I have.
Thank you. Ms. Boozy, you have Ms. Roper?
Your Honor, her notice to us was regarding an HVAC unit. We did hire somebody to come out and inspect it. As far as the phone calls, I haven't received them. I did get a
And yeah,
voice
I would
message.
like to just object and see if she first has any questions on cross-examination before she gets to rebut and start testifying.
And they're gonna do that.
That's true, that's what they do.
Did we send somebody out to do the repairs?
You send somebody, I wouldn't know if they came out to do the repairs or all, it was like some handyman. I'm not sure he was an HVC person.
But did it actually work for that short time afterward?
It blew some air.
Why did you send me another 14-day mailer?
Because I had already done that and it took you this long to fix it, I figured I would call you. And if you check my phone, I called you 7 times.
I have been out of town and out of the country and unable to access it.
Do you want to move in that apartment and stay in there at 89? Yes, Sean, I'm sorry.
Do you have the ability to pay rent today in the event that the court finds you have to pay rent?
I can pay rent if the court finds that they can fix the AC.
No further questions?
Or will you explain what the point of the questioning was?
Yeah. Typically, if you're dealing with a landlord like I am in this case, they're gonna testify with their questioning, even more so than I did. They're gonna go up there and be like, didn't you come to my office and raise your voice at my staff, and don't you have a cat? They're gonna keep bringing that cat back in. And this is the people's court, and you're gonna see a good bit of liberal use of those objections and liberal use of hearsay. It just kind of, we have relaxed rules of evidence, and that's something you're going to have to expect, anticipate, and sort of minimize as best you can. But what the landlord's going to try and show is that they were not willful in failing to make the repairs when you were demanded. So I'm trying to demonstrate that we got the notice and did hire somebody to come out. And I actually did go with somebody for the purposes of this exercise that is in the business of HVAC, but we left it kind of blank as to whether or not they are licensed. And we also left it sort of open-ended as to whether or not the repair was sufficient. So by our evidence that we're not displaying, so we didn't want to blind Ms. Roper, it does state on there that the technician finds that the unit is at the end of its useful life and is likely to need replacement. So there could be a refrigerant leak. This could have been a fix that's a bandage, and it may have been negligent or even grossly negligent, but the statute itself shows willfulness. So what we were trying to do is make grounds to show that there is wrongdoing on both sides and that there is a defense that can be raised, which is under 660, regarding diminution in value or failure to make appropriate repair and remedy under 610. And that's something that the tenant could allege that maybe they don't need to pay the full $950. Maybe there's a diminished value as to that unit.
Right, and I think that's really what comes in, because it's the statutes that come into play here, and I think we probably just skip ahead from what we normally would do that in closing at the end. And sometimes with some of these, you'll find with even Judge Michael, that if you know some of these issues ahead of time, an issue spot, you may not even get to the point of calling your client as a witness. You might just say, let's jump to what the meat of it is, and talk about this, because there might not be a big dispute of the facts. But 610 is one that says you give a landlord a 14-day notice to repair, they have to start the repair in good faith within 14 days or faster if it's related to health and safety and if it requires a faster repair. The problem here is the invoice that says there's likely a leak. It seems like a Band-Aid that's not really a fix. And they also didn't address the mold in any way, shape, or form. The one problem you might find if you have a savvy landlord on the other side or an attorney representing landlord on the other side is there is another statute kind of at the end, 790, that kind of says if you want to raise a counterclaim or defense, you have to be able to pay the back rent first or have it available to pay before you can raise that. And if there's a dispute about what that should be, maybe, and I take the position, if we're going to argue the diminution of fair market value or something like that, then you can have a hearing on, that's what they call a 790 hearing on that to address the rental amount. Most landlords are not going to come in and raise all that, and most landlords don't want to come to multiple hearings and go through all that. They just want to kind of throw it all out there at this one time and don't keep coming coming back and forth, and they wanted us to get through it. But what I would normally argue in this case in the closing would be 610, 640 gives you permission to raise that defense in an action for possession based on non-payment of rent. So it tells you that you can raise whatever claim you have under the law, and you have 610 that says you can get actual damages. You can also, if it's willful, get attorney's fees in that situation. So we found that the landlord had intentionally not come back to do anything with the mold and not fix the AC again, and was just mad at our client. You could be asking the judge to award you attorney's fees in that if they're willing to go that under 640. And she's a great, I would say that Jamie was a very good tenant, because she also said, yeah, I can pay that rent if I need to. The court determines that might satisfy you under the 790 issue.
So even though the statutes will say something about paying rent into the court, we do not have that currently in Charleston County. So, you know, if somebody comes in and says you didn't post a bond with the court, just ask the court to take judicial notice that they don't do that. Or the court will usually come out and say we don't do that. So even though the act does say that there is a provision for that, there are counties throughout the state that do receive those funds. This one does not. And so posting a bond is not really something that's practical here, and you may have not had enough time with your tenant to ask that they put it in escrow in your IOLTA account, but you can ask whether or not they have the present ability to pay. A lot of times we'll have tenants who will bring with them money orders for the amount in dispute, and if they get to keep that money order, it goes back in with them.
Can you guys quickly cover what happens if you realize that there's potential to sever and file a small claims court for damages and or attorney's fees, just what you want them to say, and then how you get the tenants to one of our legal aid groups?
I mean, I think it just depends on what the claim is, because I usually take the position in front of from the eviction that 640 allows me to bring up whatever counterclaims, whatever I want that day. I was just at the magistrate training on a panel yesterday, and there was a whole big ruckus about about that, and they're all over in different counties. So some counties and some magistrates are more willing to say, yeah, I agree with you, and you can ask for attorney's fees right then and there, and just maybe testify about what your attorney fee would be and the amount of time. If you're here that day, it might be an hour that you'd be getting or something like that. But there are, you might have someone who has very little money, did not bring with them the money to pay rent, or maybe they were behind in rent before this other problem came up. That does not necessarily mean they don't have a claim at some point, maybe for some damages, but if they're behind in rent before the HVAC problem comes up, then a lot of times that prevents you from being able to use that as a defense, and your client might be put out. I have the issue, I don't know, Nicole, what you see, but I see a lot of things where people come in and they say, well, they didn't do this repair, whatever, and then I got hurt. And they start turning it into a personal injury or tort kind of issue. If and I have to wind back and say, that's not going to be dealt with here. You're going to have to file that separately and go down a different path with that. Retaliation is one of the other things. If you haven't given the 10-day notice, you can ask for a continuance if, let's say, a judge did not grant that continuance for the retaliation. Or whatnot, or if the person may have moved out, you might say, well, they moved out, you can then, that retaliation claim is still good. They can still file it as an affirmative claim, whether they've moved out or not, and that brings with it 3 times actual damages or 3 times the amount of rent plus attorney's fees in those. So those are ones that I primarily see that sometimes you're not going to know a lot ahead of time. You might come in and they go, wait a minute, this is retaliation, because if Jamie sent that 14-day letter and then Nicole said, okay, 30-day notice to vacate, I'm going to terminate the lease, that's usually a pretty good retaliation.
So we actually have had a few cases where tenant gives 14-day notice in the middle of a lease term and landlord immediately turns around and files, and then the case that they bring to the judge is, I can't afford to do the repair without them actually paying their rent. Well, then that's, you can't afford to be a landlord then. So that's really what that is. Now, I will say in cases like what Matt's talking about with that personal injury, an example from practice that we've had to sever damages and move it to a different court. I had a tenant who they had notified their landlord of a gray water flood that was originating from a unit above. The landlord did a very unusual remedy for that, which was basically invert a shower cap in the bathroom, and then the shower cap was catching the gray water, and it fell and it splashed the tenant with unidentifiable dirty water, and then the tenant got sick. And it may have been, you know, a regular illness, or it may have been related to being splashed with a gallon of gray water. But this was somebody who was in advanced age, and they had medical expenses, so we moved to have those preserved, severed for a later claim, because you can sever those damages and bring it at another time, especially when they are medical damages and you can show that there was something related to the tenancy or a negligent repair. You're going to want to do that, because your better remedy is going to be in those damages elsewhere. But again, if it's possessory in here, you're not limited to the $7,500 statutory cap, because it's possessory in nature, and so the statutory cap is lifted.
Just what would you do, let's say, I know that we see this a lot, you know, Jamie comes in and she hasn't paid rent, and during the screening process, she's like, well, my AC doesn't work, I have rodents, et cetera, is wrong with my unit, but she didn't give the 14 days written notice necessarily. I mean, what do you tell her at that point? And what do you do? Even if, let's say the issues are real, she just maybe hasn't followed.
Or get it to somewhere in that nature. But you still can bring it up if they have any notice. If they don't have any notice to the landlord, they're just kind of out of luck. If the landlord has no notice, then they haven't had the ability to act on it, and you're essentially barred from raising that as a defense. You know, so I think 640 does talk about how long you have to give them notice ahead of time before rent's due.
14 days.
14 days that they have to have notice before rent was due, so that can be another impediment or a problem. If maybe they gave verbal notice maybe a few days before rent's due, and it doesn't really specifically say you can withhold rent. I usually advise clients to not withhold rent unless they are having to pay for essential services to get fixed and deduct, and that's statutorily allowed.
Tell them what essential services are.
Well, that's another good. Always look at the definition of essential services. Is generally plumbing, sanitation, heat, reasonable amounts of heat. So, you know, not heat in the summer, only really probably a few months time here. Electricity, running water, hot water heaters, reasonable amounts of gas. I think you can choose from like
Cooking or heating water.
heating water, so that kind of thing.
Not AC.
So that's. I get that question all the time, and people will say, "Are you serious that air conditioning is not an essential service and all these other things are?" And yeah, and especially somewhere like in South Carolina, you have, you know, reasonable amounts of heat as essential service, but not reasonable amounts of air conditioning.
And I will say that we did try the converse by saying that the way the statute reads is adequate heat or sufficient heat. So we actually did try and make the argument one time that too much heat is inadequate. And the court was like, nice try, Ms. Paluzzi, I appreciate it, reminded, but no.
But it's not to say that the landlord doesn't have a duty to provide air conditioning. If
They have to.
if it's already there, and it is, especially if it's specified in the lease, I mean, you're looking at
Right.
the contract first.
Yeah.
And, you know, so it's not that, essential services carries different weight under the statutes
Right.
than the repair of other
The
non-essential services.
landlord's obligations are under 440, and they do say include air conditioning and have to keep it in good working order and the like. But if it's essential services, you know, if it was in the winter and it was heat, then Jamie could have paid to get that heat fixed and then sent a notice saying I deducted this, here's my receipt of what I paid to have to get the heat fixed. And that's valid under the Landlord Tenant Act. So.
And those forms for procure and deduct notice are included in the handbook.
But I mean, a lot of times those are going to be, you know, not the norm. Most cases you're going to get in is either going to be a violation of the lease, noise complaints is one of the very common one, or you know, the non-payment of rent issues. You also get the third option in there, which is end of the lease term. So a lot of people end up going for a year, then they're on a month-to-month lease, or it's a verbal lease and that's month-to-month. And you'll see that a lot where I just want this person to move. I just want to have them out. And at that point, really what you're checking on is, are they on a month-to-month notice or lease, and did they give the proper notice under that? One thing I see with that is they'll give the notice in the middle of the month. If their lease runs the 1st and the 30th, they'll give the notice on the 15th and say, I want you out the 15th of next month. And I always argue, well, that's not a valid 30-day notice because your lease term is the 1st to the 30th of every month. So prior to the start of that next lease term, you got to give notice that that's the last one. So those are sometimes ways you can either clarify it for the court, show that your client really should not be put out in short fashion. If there's an ejectment issued, they generally have about 5 days to issue it, and those things they can have a quick turnaround if somebody's ejected. So there's usually I put them into those categories, and then you just try to figure out.
Yeah, and just to add to that, it is 50-50 on whether a landlord has done the proper thing to get an eviction. Maybe even higher percentage that the landlord has not done the right thing to get the eviction. So these threshold issues are common and important, and you'll find them a lot. And one of the goals of this court is that perhaps we can educate the landlord community, because if they run up against enough lawyers who are smart and can tell them, you know, defeat their eviction if it's improper, then that'll educate the landlords, and we don't have all these evictions being filed where there are grounds, where there aren't grounds for them. So that's one of the goals. I would think one of the overarching goals is to make sure that tenants are not being evicted when there aren't proper grounds to be evicted. And I think education will be key to that. You're all gonna, even if you've never touched a landlord-tenant matter or read the act once before today, you're doing better than your tenants are, for sure, because you're a lawyer and you're smart, you can think on your feet, and you can get something better than what they're doing, for sure. So you're already creating such a benefit, even if you feel uncertain that you're not going to be the top lawyer on landlord-tenant stuff right away. You'll get there. It's a finite body of law, and a little time with the statutes, the 600s and the 400s.
Now, I would say that you'll probably thin out the group pretty quick if you look at notice issues first. And if you get 5 or 6 people coming in, you know, which ones are non-payment of rent, which ones are a breach of the lease, and which ones are end of the lease term. All those have the notice provision. Rent is a 5-day notice and right to cure. That's usually in the lease, but a lot of people, you'd be surprised how many people come in and they don't have a written lease, it's just verbal. So what that means is they've never gotten that 5-day notice most likely, and there has to be a separate 5-day notice that this is what you haven't paid in the rent, you have to pay it or I can evict you. And they could be 3 months behind and they've never gotten that 5-day notice. You know, you can get the case kicked out, so you got to go give them a 5-day notice for them to have a chance to cure it. So there's always a notice there on rent, there's a notice on the 14 days like we did here, there's a 30-day notice on a month-to-month tendency there. And you'd be surprised at how many people on cases will come in and you can get tossed out, just identifying which category and if there's a notice issue to start with.
There's only about 15 minutes left of training, so we want to have a question and answer opportunity for the people watching.
I have a question. If we, say we walk in and the mock by you guys just said, that's the facts we've got, right? With that, and I'm watching all do this in my mind, I'm like, well, I want to investigate this HVAC issue. I want like some pictures of the mold. I would maybe want the HVAC guy as a witness. Like, would that be a continuance case? You can do that, or am I over?
It will depend, but I do want to make it very clear. We do not have subpoena de tecum in this court. We do not have discovery in this court.
Right.
You can ask opposing party or opposing counsel, whomever, to give you something, and if they say no, then they say no. You have no motion to compel. It's a lot of trial by ambush over here. Do not try and issue a subpoena de tecum. There's actually a case for lawyer discipline on that magistrate court, so don't be that person. But you can subpoena a witness. So there is a form you can go to the clerk's office and ask for it. It's $7 and $25 for their appearance and mileage to and from the court. But if it is somebody like the building inspector and you have this wonderful report that says I investigated and the place was found to not be compliant, you may have that report with you on day of, or you may need to get that inspector to come testify to it. I do not regularly ask the inspector to come testify to something unless it is extraordinary. We've had cases that were 6 inches deep in water in the apartment and the people were just sick of having to slog across their house because nothing was getting fixed. You open the door and the water goes out.
But the judge will look at the report. You don't have to have the
Alvin coming in.
So again, a little bit relaxed in terms of evidentiary issues. There's a lot of hearsay that comes in here, and you can object to preserve your record. I'm never gonna, but I probably I may deny it. But I want to hear what's going on. And almost nobody brings the actual witness.
Yeah.
They're gonna bring the document like the Crenshaws.
Or they're gonna bring their cell phone and
Yes.
show the court, they're gonna walk over to the
Absolutely.
judge and show them the
Yes.
text messages
And
and
that
that
is
conversation
fine.
they have with somebody else.
Yeah.
That is fine. I would prefer if it were printed, but it almost never is. What do we do with that? I end up reading it into the record so that there's some sort of, something besides just my memory of what I saw when I read it, when they handed me their phone. So if it's a text message thing, and I accept notice from either party on text message, even if it's not printed out. So we're just gonna, again, be reading it into the record to preserve it as best as we can for that. So it's not savvy folks.
Do what you can to authenticate the documents as best you can. Now, we provided evidence that was, a city official's business record. That there are, exceptions that you can have that brought in, invoices that are a landlord's business record, and then documents that are tenants. But you will see a lot of like email conversations that are maybe not something that are readily authenticated by the handles on the emails. And you may also see text messages where it's like, we can't confirm this other person's number. If that's the situation, do as best you can. And if you have to ask that the record be held open for the purposes of authenticating something, make that request to the court and they may grant it.
I would also just say, talk to the landlord beforehand. I mean, talking about investigating things like that. Like, first of all, the captain's gonna get kicked out because of the notice. You don't need to do any discovery on that. With the HVAC thing, if you can talk to him beforehand and say, hey, she gave you this notice.
Right.
We now know that you sent somebody out there, but it's still not working.
Right.
You can get a sense of.
And she's willing to pay.
Yeah.
As soon as it's fixed, so
Right.
it seems like that could be.
It could be resolved without getting into the nitty gritty of the useful life of the HVAC system. Like, you can, he may say, okay, we'll get somebody out there, this goes away, she'll pay the rent as soon as somebody's out there, everybody wins. It can be, that's usually how things happen. So,
A conversation really.
And
You
I
don't
would be
need to-
surprised if you actually get a case that has probably that much evidence.
Right.
And most of these don't, if they have that much evidence in it, they've probably already gotten to one bus or has been continued. But if it does have a lot of evidence, or you see there's a lot, and you want more time to do it, and you want to come back and try to nail that landlord to the wall, and just ask for continuance, saying you're gonna need more time to try it, because they're not gonna want, I've had magistrates tell me, if you have a case with this particular landlord, and sometimes they get their attorney and sometimes not, but if you get a case with them, tell me ahead of time so I can block out like half the day, because they don't want us coming in there and spending 2 hours while everybody else is just kind of sitting there for 5 minute, 10 minute hearings.
And most landlords come with a billing ledger that's nowhere near as clean and succinct as the one we presented. You're gonna get something that's like 20 pages long with 1 million adjustments. Or none at all. Yeah, or none at all. We've had landlords come in and say, I just know that they didn't pay this month.
right.
And I never issue receipts.
All right, so if you get someone kicked out because the notice wasn't good, and we already discussed that they could then go and file again once they've given the 5 days notice, or the 14 days notice, or the 30 days, you would behoove your client, would benefit your client if before they left court that day, you just let them know, you actually have to fix this problem.
Right.
It might seem intuitive to you to tell them like, hey, that you've got to pay the rent, but actually tell them you now have to pay the rent, or the rent is now due. If they need additional further information or it's beyond what you're comfortable advising, you'll have all of our contact information based on them being eligible for housing court. They're eligible for all of our organizations. Give them our contact information and they can get even further representation or advice and counsel at one of our
And
offices.
it may be a great opportunity to refer them to Trident Urban League. If it's just that they couldn't pay, they're a little bit behind, they need a little help this month, they could get that rental assistance and prevent them from coming back in a month or two.
If it's a documented one-off hardship, we have a lady who was suddenly diagnosed with cancer and found herself inpatient, so she had a medical hardship, but she was likely to have her short-term disability kick in and be able to compensate for the next month. So those are the ideal situations where it's kind of like Hurricane Dorian hit and I lost an entire week worth of wages, so I'm going to be short for the following month. Those things happen, and that's what emergency rental assistance is for. Or if someone says I've been 6 months behind in my rent and I have no job, I have no source of income, and I'm not foreseeing getting any source of income, then really for them it's negotiate that put out date.
What's your question?
Well, what happens when that client calls you back after maybe you've gotten the case kicked down because of improper notice, and then the landlord just walks to the window and refiles because the 14 days has expired, and then that client or that individual calls you 2 weeks later saying,
So you
"They
have
just
the,
sued me."
you have the limited
Closure.
record.
Yeah,
And
case is closed,
it's
and they get a copy of that.
It's
You
in
can
let
But
them
they're gonna have
know.
my name.
Right.
Yeah, let them
Then you
know
give
that-
them the legal services
Yeah.
organizations.
Yeah.
Give them their number. Unless you want them.
Well, yeah, I mean,
You
it's-
can do
I
that
guess
on your
it's-
own.
Just be clear with them that, you know, with this limited rep, this is when I'm only representing you for this case.
That may be a good opportunity in an instance like that, where you know that there's gonna be a refiling almost immediately, to talk to the landlord, because, and feel out if there is an opportunity to resolve this. The landlord doesn't wanna have to come back and refile and wait, 15 to 45 days for the next set of service, et cetera, for the whole thing to play out again. That may be an opportunity for you to step in and say, landlord, what's the real issue here? Is this person gonna be able to stay? Are you looking to just get them out? And then try and broker something that gives your client enough time to make arrangements if staying there long-term is not gonna be the reality for them. So I would say that, because that would, the landlord's probably gonna refile anyway, just to save themselves the time to, not kick it down the road and then have to file and wait time. But if you can do something before the next writ of ejectment, which is, so 3 stages to an eviction, you have the filing of the eviction paperwork, and the first step is the service of the rule to vacate or show cause on the tenant. That lets them know that the landlord is evicting them. They have the 10-day window then to request a hearing. If they're personally served, that 10-day window starts to come immediately. It starts immediately. If the constable is not able to personally serve them, but has to post it one time, the constable then has to come back out 48 hours and plus 8, so like 56 hours later, and post it again. And then if they didn't get personal service that second time and they had to post it again, it's not completed yet. Service is not completed yet. Service has to go back through the court. The landlord has to come back in and pay $5 in person or mail us a check in order for us to mail out the rest of it. And once we mail out to the tenant the service record that we posted twice, then 21 days after that, 11 days from mailing, 10 days to request a hearing, is when tenant is fully notified and the whole thing is ready to move to the next step. So there are a lot of steps there, and it takes a lot of time. The writ of ejectment would be the next step. So once tenant is aware, and we know that tenant's aware because they've been personally served and the 10 days has elapsed and they didn't request a hearing, or they've been served by mail, by posting in mail, and the 21 days has elapsed and nobody called to request a hearing, the next stage there is the writ of ejectment. If in this next filing, your landlord doesn't have to get all the way to the writ of ejectment, that can save your tenant's rental record in terms of not having this an eviction that will go forward and will go all the way through. If you can broker something within that range of time there, then you're saving the landlord a little bit of work and you're saving your tenant a rental record, maybe preserving it without an eviction if that's important to them.
And while y'all are under no obligations, after that hearing is concluded, if your tenant is unhappy with the result, do at least let them know that the timing is different for landlord-tenant actions. If they want to move for reconsideration, they've got 5 days. It's not the usual timing requirements. And if they want to notice an appeal, you're not obligated on that appeal either, but they need to notice their appeal and get that started within the 30 days as well. Again, that's not your duty to take that case, but just as a matter of closure and talking to your tenant, making sure that they get compliance on any issue that they have outstanding, do let them know that the timing is different, and then we'll need to consult with somebody if they are looking for some after relief.
Yeah, and if they do want to appeal, I will say this, yeah, it's 30 days, but not really.
Not really.
Because if they don't get an appeal filed prior to that ejection being issued and actually executed, then that appeal is not going to do anything for them. They're not going to appeal when that gets to the apartment. If they want to stay the ejectment and stop the actual eviction during the appeal process, they have to file it before they actually get put out.
And post a bond.
All right, we're getting into the weeds.
Wait,
Yeah,
yeah,
we're
that's
not
not.
So who's going to be our first attorney on October 2nd?
We already had,
Everyone.
we already had people call.
Who's gonna be our October 9th attorney?
Good, look, people raise their hands.
I gotta read the materials.
It's, I mean, we're
In
throwing,
paper form.
we're throwing a lot, I think, at you at once, but most of the cases that come in are not gonna be as complicated as this, or as much evidence. It's gonna, and it seems scary to say, I don't have any information on this case at all, and I'm just giving it, I get it that morning. I mean, that's kind of what I end up having to do a lot over the years. But you learn to just issue spot really quick, and, you know, it's just, I filter them into those categories. Y'all don't have to worry about subsidized and Section 8 and all that stuff that gets extra more complicated. You know, and there's other ones that I've had in here before with all kinds of messy stuff. So y'all don't have to worry about that whole side of it. It's just, do they pay rent? Is it an issue of violating lease, or is it an issue of it's an end of the lease term? And like I said, well, you move into that, look at the notice, and probably a third of them might fall away really quick. And then you can probably issue spot, tell the judge, I'm ready for 3 cases. Notice on this one, notice on this one, notice on this one, and get them kicked really quick if they have those notice issues. I wouldn't even, you know, you can negotiate obviously for whatever your tenant wants to do, but for those, and if I'm bringing them in there, I put that at the very beginning. That landlord's over there ready to yell and fuss about everything else, and I'll say, Judge Michael, they didn't send a 30-day notice to terminate this person or whatever else. Oh, did you not send a notice? No, well, you got to do that. Got to dismiss it. Case is over in like 5 minutes. So, you know, it's not as bad as it thinks. And the Landlord Tenant Act, if you look at it, is really not very long. It kind of gets confusing. It's not. Some of it when you get too far out in the weeds. Almost, you know, dealing with that magistrate yesterday, you can see how some complicated issues, but this is designed just to help people with the regular, basic, run-of-the-mill cases coming through here, to help them with those issue spotting and those notices. Because a lot of tenants may not know that I was supposed to get a 14-day notice and right to cure, or that, you know, that 30-day notice wasn't exactly a valid one, or something along those lines.
You could also come observe, so since we already have an attorney scheduled
Yeah,
for 10 too, you're welcome to come
Wednesday
and
you
just
wanna
sit and
come?
watch.
Yeah, I mean, you never know. And I mean, you can always come and watch one of us. I know I talked to Sharon about doing that, and all the cases I had kind of like didn't happen. They either, somebody's like, no, I moved out. One person, well, I'm in like Kentucky now. I'm okay. So that one just hasn't been rescheduled. That one was a little different with a trailer in a trailer park, which is a different law, similar but different. So you never know what will happen, but you know, if anybody wants to observe, I'm sure Nicole would mind. She has probably more hearings around in the area than I do, just because I cover a lot more ground in other types of cases. So
Pick a day. Y'all want to come with me?
Go observe them first, but I'm gonna go get my docket, and I'll tell you, we probably have a Monday docket, if you just wanna come watch a couple of eviction hearings, and maybe even a Tuesday docket for this coming week from the Graham, and I'll let you know.
Nicole, you mentioned something about an IOTA account. Now, payment is transacted between the landlord and the tenant, right? I mean,
I'm saying that we don't have in this county a court where the tenant can pay rent into the court. Some of the statutes will say pay rent into the court and bring that action. We don't have that option here, even though the statute states it. So what we usually ask our clients to do is to either move it into a separate savings account and show that the funds are there and ready to be able to be paid. Or if we have a lot of unbanked clients who would either put into our trust
but you don't have an IOTA account at all.
You're
No
fine.
one's
You
asking
guys
you
don't
to
have to do
No
that.
one is asking you to have.
That's
it.
just
I'm
the
just
red
saying
herring. You don't
that-
have to do
That is an option if you're trying to show compliance on the tenant's part, but usually just letting the court know and letting the landlord know as well that this county does not receive rent into the court. But what we've done is this alternate thing where it's, you know, I put it in my alt account, or here are the money orders, we have them right here, or here is, you know, $6,000 in cash, and we're gonna decide who gets it at the end of the day. Just to show present ability to pay.
And you can just tell the court she can pay. Just do like what they did and have your tenant say, you know, I have the ability to pay as soon as this gets finished. And then that's it. Yeah. Don't worry about putting anything.
Everyone, please make sure you sign the sign-in sheet to get CLE credit if you did not. It's up here.
And we don't have a big docket for next week, but I do have Thursday, it looks like Thursday the 26th, 10:30 and 11 o'clock back-to-back, 2 eviction hearings. They could fall through, so just, you know, don't be excited.
Can I ask a logistical question? So when we get here, whenever we're assigned on that Wednesday, we come at 8:30, so we only have that 30-minute time period to do the screening and the intake, plus meet with the landlord for all the cases, or do we have time in between? How does that?
If it's not a big docket, you should have time in between.
Okay.
Yeah.
In as
Because
much
again, we're
time
gonna
as you
try
can.
to do 30-minute
Okay.
increments, and then come back in, and we're gonna schedule everybody at 9, 9:30, 10, and then once we fill up all
Yeah.
those, we're gonna go back and do, 9:15, the 15-minute increments after. So we're gonna try and allow for 30 minutes between, and that should give you.
So the tenants are asked to come at a specific time, or do they?
So
are they
I have to
supposed come
clarify
at
that,
8:30?
'cause-
Yeah.
so I have to clarify that. I think we've been telling them to come 30 minutes ahead of their
Okay.
hearing,
Okay.
but if we need to call them to reschedule that, we can, to get them here at 8:30. But I think just for purposes of missing work, we've just been saying, be here 30 minutes ahead of your hearing.
And we'll meet with the law students to start.
Yeah, so at 8:30, you're probably only gonna have one tenant here. Yeah,
Okay.
it won't be a crowd.
And the law student is just there for the intake and
Yes.
screening? So
Yes.
during the hearings, will they be watching? Could you refer to them and be
Yeah.
like, can you pull that statute for me?
Yes, some of them have said that they would like to attend
Okay.
and they would like to be available to assist. And then the law students have a doodle as well where they sign up, and so they can say if they can stay for the entire time or part of the time, so you will know that ahead of time.
Okay.
So right now, on the second, we only have, for instance, 3 hearings scheduled. The 9 o'clock canceled, it fell through because I think we had to cancel, and it's now for a different day. So we'll probably fill in the next person who asked for a hearing at the 9 o'clock, but right now it's only like 9, 9:30, 10, and 10:30. So we're gonna try and schedule them in a way to get you in and out of here.
I think one of those will come off.
One of those, what?
One of those is going to come off. I think.
Yeah,
The
probably.
second.
I would not be surprised because.
Well, no, not like they are. Yeah.
Yeah.
I just have.
Is the docket accessible somehow? No.
It's accessible via US.
Oh.
It's a book.
Anybody that wants to come in with me to court on Monday, I have a hearing in West Ashley at 3 p.m. It is landlord alleging non-payment of rent by tenant. Tenant is going to show a building inspector certification that her unit has swarming termites. She's going to show 4 reports of termite inspections showing that there are live termites. Landlord has responded with one that says the termites aren't actually in her bedroom. So, again, it's a fairly thoroughly evidenced landlord-tenant case, and there's counsel on both sides. The allegation is tenant is 1 month behind rent with tenant's notice to landlord to correct the termites, and the termite issue's been ongoing for about 6 weeks.
And where is that court?
West Ashley, it's on Sam Rittenberg, 1240 Suite 1000, I think.
Used to be Goodwood right beside it or something like that.
It's right next to the Windjammer Apartments and $1.99 shirts cleaned here. If y'all.
And
Yes.
Dakotas.
Yeah, Mikado.
Yeah, it's right there.
Big building.
Yeah, it still has a sign that says Ucoso.
So because there are so many of you, we're so excited that there are so many of you, thank you for being here. We hope to be able to roll out to the North Area 3 Court, which is Judge Sunday's court off of Rivers Avenue, what used to be Sam's Wholesale, if you've been here long enough, but it's now At Home or something like that. And so her docket would be 2 days per week because she has a huge docket. She does double, if not double and a half, the number of evictions that we do here. And so her court will be the next court to be rolled out, and we would need attorneys to staff 2 days in her court, which I think hers are the Tuesdays and Thursdays will be her days. So then we will need attorneys to be able to volunteer for Tuesday, Wednesday, and Thursday each week. So it's just a matter of what your doodle surveys tell us and how many of you are available as to how quickly we can roll that court out. We want to start this one and make sure we can kind of smooth some hiccups here, or maybe, but we'd like to get it started as quickly as we can. The Supreme Court's given us a 1-year pilot project, and we'd really like the courts to be operating, and then we will eventually roll out, hopefully, to the West Ashley Court as well, that we were just mentioning, Judge Steinberg's court. And that will be Mondays.
And so just, if you know anybody who would be interested in volunteering with this project, outside of the people in this room, just have them email Jeff at the email we posted earlier, and we'll, be in touch with you guys. We'll be able to kind of give them some info as well. We'd love to help.
So if anybody wants a manual in paper, I'll be happy to copy it for you. You come and pick it up at 180 Place.
For the purpose of professionalism, let's say I have every Wednesday with the foreseeable future done, and I put every Wednesday on this, can I put on my unavailable day, hold, once you get back and clean it up, hold morning of Wednesday as unavailable, you know, we do.
Oh, you,
So let's say, I'm
Oh,
saying
okay, I
I'm
gotcha.
available every Wednesday right now in pretend land. And I sign up and tell you guys I'm available every Wednesday. On my unavailable dates, as they're circulating, can I say, hold open until you make determination when we're to be assigned? For other scheduling matters.
I mean, you can, that's totally up to you. I think we'll be giving you, our goal is, Jeff, how often do y'all, how far out do y'all want to schedule out?
We're gonna do the end of the year now, right?
Yeah,
Yeah.
we're going to schedule to the end of the
So
year.
you'll know whether or not you're gonna be scheduled, you know, pretty soon here, because we're gonna start scheduling through the end of the year right now. So you don't have to have all your Wednesdays on hold. You'll know, you know, we have you this day and this day.
And you'll see a couple of those will fall to a Thursday maybe because there's Christmas is on a Wednesday, we're not doing eviction. We're doing Christmas.
Although people file.
Mainly because, and then also the New Year's Day follows the following
Yeah.
Wednesday. So you'll see a couple of days that aren't Wednesdays, and that's the reason, just the holidays or some conflict.
All right.
Thanks for coming out.
Thanks, guys.